So without further ado, let's get started with today's webinar. As I mentioned, I'm Margaret Ioannidis, the Associate Dean of Strategy and Innovation, and I work with Florida Coastal's LLM programs. With me today is the Director of Experiential Learning, the Director of the Immigrant Human Rights Clinic at Florida Coastal School of Law, and Professor of Law here at Florida Coastal, Professor Erica Curran. She teaches courses in immigration law, including for our Logistics and Transportation LLM program. She is also an active member and leader within the American Immigration Lawyers Association. She served on the board of directors of the American Immigration Lawyers Association Central Florida chapter. In addition, she's the co-chair of the AILA Student Committee and co-chair of the AILA Advocacy Committee. She has also been an invited presenter at AILA conferences, including at the AILA National Conference and the AILA Central Florida Conference. Professor Curran has also served on the Mayor's Victim Assistance Advisory Council in Jacksonville, Florida. She obtained her Bachelor of Arts degree from the Evergreen State College and her law degree from Seattle University. She's put together a wonderful presentation and will be focusing on immigration law, transformations under a new administration. So without further ado, I turn things over to Professor Curran.
All right, so this is certainly an interesting time in immigration law. This is going to be a fairly significant transformation based on some of the campaign topics that were campaigned heavily on. And, you know, myself, having practiced immigration law for many years, I think we're going into some uncharted waters. But there are certain aspects of what one campaigns on and what one is actually able to do that I think are really important to figure out and think about when you're listening to many of the things that you hear on the media. So during this presentation, we'll cover an overview of the system, a system of checks and balances, what exactly the executive branch can do, what requires congressional action, and we'll also take a look at the judiciary, what their role will be. We're going to speak about specific changes that are anticipated based on the campaign promises related to executive action, enforcement, and business reform and immigration. And I think the starting point is oftentimes, and this happens on all sides of the political aisle with both parties, when a politician is campaigning, they often make promises about things that they're going to do that the executive branch simply doesn't have the power or authority to do independently. One of the most sort of important aspects of the American governance system is the checks and balances between the executive branch, the legislative branch, and the judicial branch. So there are certain aspects of immigration law that the executive has control over, such as regulations or executive actions. But Congress passed the Immigration and Nationality Act, and any amendments to our immigration law have to go through Congress. And then they have to stand the test of judicial scrutiny. So if we pass laws that are not constitutional, you know, the judicial branch will take a look at that. So, for example, during the Obama administration, he passed some executive actions, or some executive actions came through his office related to DACA and DAPA, which are two forms of immigration relief, DAPA being deferred action for parents of U.S. citizen or LPR children, and DACA being deferred action for children. And those executive actions were made by the executive branch independently. Now, it wasn't something that President Obama was the first president to do executive actions. When he came into office, he reviewed over 291 executive actions that were in place from the prior Bush administration. So approximately the same amount of executive actions will be reviewed by the Trump administration when they come into power. But two of those executive actions ended up before the Supreme Court in a 4-4 decision because they were determined to have to be challenged based on their constitutionality. So there is a balancing system that's going to make certain things that President-elect Donald Trump campaigned upon not so easy to do independently. So he will have to work with Congress and will have to ensure that anything he does passes the test of constitutionality. So what happens to Obama's executive actions? So we'll talk specifically about a couple of them that may go away. But as I said before, over 291 executive actions were in play when President Obama took office from former President Bush. So the executive branch often comes out with executive actions or memorandum. And essentially what these are is the executive branch telling different agencies and organizations on how to do a certain thing. In the case of the Obama administration, what received the most attention was the deferred action for parents and deferred action for childhood arrivals, which is a form of prosecutorial discretion. So what is prosecutorial discretion? Prosecutorial discretion has been in play for a long time, and you think about it most commonly when you're thinking about criminal cases. So when the police arrest somebody and they bring charges against somebody, they don't always prosecute that case. The state attorney or the appropriate authority will review a case and make a determination as to whether or not that case should go forward. So, for example, police in a moment make an arrest on a domestic violence, and then, through investigation, it comes to light that they actually, there wasn't domestic violence, there was something else going on, some type of custody dispute, and the allegations were not strong enough to warrant prosecuting the case, and they've exercised their discretion and declined to move forward. The same applies to immigration. So prosecutorial discretion is the authority of an agency or officer to decide what charges to bring and how to pursue a case. And a law enforcement officer who declines to pursue a case has favorably exercised prosecutorial discretion. So the authority to exercise discretion in deciding when to prosecute and when not to prosecute based on a priority system has long been a critical part of U.S. law. And the Supreme Court has made it clear that an agency's decision not to prosecute or enforce, whether through civil or criminal processes, is a decision that is to the discretion of the agency. So in this regard, the Obama administration issued several executive orders related to their priorities or prosecutorial discretion memorandum. So they focused on removing certain types of individuals through those memorandum. And President-elect Trump is likely to have his own priorities, so those are likely to change. So prosecutorial discretion can be exercised at any stage of an immigration case. So specifically can be exercised when deciding whether to detain someone, to start removal proceedings, focus enforcement resources on particular violations or conduct, to stop or arrest a particular person or detain or release someone on bond or their personal recognizance. So you're going to see likely changes in the executive position on that. A lot of Obama's decisions were based on resources and priorities. His administration saw a focus on criminal deportees with certain types of convictions, serious convictions, a priority. Individuals with long-term ties to the United States who had, clean records were less of a removal priority. Also, individuals with recent unlawful entries were a removal priority for the Obama administration. So there was a memo that Obama issued to the executive that said, when you're making decisions, these are the priorities I would like you to follow. And so we anticipate that will likely change. So some examples of favorable exercise of prosecutorial discretion in immigration might be to close deportation or removal proceedings, or stop deportation, or not to issue a charging document in the first place. So in the past year or so, I have had many cases closed that were in removal proceedings under these circumstances. So, for example, represented somebody who had been in the United States for 7 or 8 years, worked without authorization, but otherwise had a clean record, had U.S. citizen children, but still no ability to obtain lawful immigration status. Under the Obama executive actions, this individual was not a priority to be deported, and so in negotiation with the Immigration Customs Enforcement Office of Chief Counsel, the two parties, our side and the government, decided to administratively close the case. So the person wasn't in deportation proceedings. They're still in proceedings, but they're not actively, the government isn't actively attempting to deport that person. So that was a decision that was made prior to the Obama administration. That really hadn't been done as frequently, so that was the case. However, in other circumstances, individuals who might not have been deported under the Bush administration were deported under the Obama administration because he had really clear priorities about foreign nationals with criminal convictions. So ICE, Immigration Customs Enforcement, ICE, which is the enforcement branch of the Department of Homeland Security, which is the main agency that deals with immigration, USCIS, which is the benefits side of immigration, and Customs and Border Patrol, which handle the border protection, all have the authority to exercise prosecutorial discretion, and they may decide not to place a person in removal proceedings by issuing a notice to appear, which is the charging document in immigration. And other decisions may be made at a higher up stage. Often the cases that I dealt with were individuals already in removal proceedings, and we were working out with the ICE officers based on favorable aspects of our client's case, whether or not they were going to go ahead and close the case out. So prosecutorial discretion can be exercised on a case-by-case basis, and then sometimes the executive branch can make an announcement implementing enforcement priorities on an agency-wide basis. And that's an example of prosecutorial discretion that was utilized by the most recent administration heavily, and also by USCIS. It adopted new policies establishing a procedure for surviving spouses and children of deceased U.S. citizens who were no longer able to apply for permanent residence, to apply for a type of deferred action, which meant they weren't getting a green card, they weren't on a path to residency, but they were no longer a priority for removal. We also had the same apply to spouses of military service members and veterans. They recently expanded that to include widows and widowers of military veterans and service members. So we recently were able to obtain a parole document for the widow of a long-term military service member. Department of Homeland Security officers that decide to cancel a notice to appear that they think wasn't properly issued can also exercise favorable discretion. So sometimes they might just close the case on an individual basis, looking at the individual facts. So DACA, this is what received the most amount of attention, and we at the Law Clinic here at Florida Coastal in Jacksonville, and many different nonprofit organizations and law clinics around the country are offering information sessions to the community on DACA and what to expect under a new administration, or sort of guidance for individuals who have DACA or who may have DACA. DACA stands for Deferred Action for Childhood Arrivals. So you might have heard some talk about the Dreamers. For many years, legislation has been proposed, the DREAM Act, which would offer a pathway to citizenship for children who were brought to the United States, or individuals who were brought to the United States as children, typically under the age of 16 when they were brought here by their parents or other individuals, and then fell out of lawful immigration status or had no lawful immigration status, who had graduated from high school and were pursuing additional education. And so DACA first came into pass in 2012, and what it was was a response to Congress's failure to act on the DREAM Act. So the DREAM Act had been proposed with bipartisan support. Frankly, it was not something that that didn't have bipartisan support, and the DREAM Act was not passed for many years. And so the Obama administration took what it considered to be a form of prosecutorial discretion and issued a policy memo that allowed certain undocumented immigrants who entered as children to receive renewable 2-year periods of deferred action for deportation. So they were not deemed to be priorities for deportation, and they were eligible for work permits. And many of the young people who advocated for the DREAM Act, the Dreamers, as they were called, really were instrumental in getting the Obama administration to issue this deferred action policy. Young people walked, and I remember even here in the clinic, there was a group of young people that walked all the way from Miami to D.C., and they stopped and stayed in the homes of some students at Florida Coastal on their way to sort of demonstrate to the executive branch that they were here through no fault of their own, and they were going to college, and they were contributing, and they wanted to be recognized. And there was a really sort of high-profile individual, John Vargas, a reporter who did a front page newspaper article, and he had a great TED Talk in the New York Times, coming out as an undocumented immigrant, and that was also really instrumental. He was a very highly regarded Pulitzer Prize-winning journalist who himself was also undocumented, brought here from the Philippines by well-intending family members, and realized, in his teen years that he was undocumented. And I myself have represented through the clinic. We've represented a number of young people in their DACA applications. So we have students at all the law schools in the country, including Florida Coastal, who have DACA as a status. And the challenge with DACA, and we all advised people when they were applying for it, is that because it was a form of executive action by the administration, it was not permanent, like the DREAM Act. If the DREAM Act had passed, there would be a way for these individuals to have permanent status, and the DACA is just a renewable deferred action that President-elect Trump has said in certain aspects of his campaign that he was not going to continue. It seems that it's not entirely clear what will happen with DACA at this point, but it'll really largely depend on what policy priorities he has with regard to immigration. But certainly anyone who has DACA is concerned, and anybody who is eligible for DACA and was thinking about applying and hasn't yet applied needs to heavily consult with an immigration attorney. The application for DACA, certainly if you applied today, it would not be approved before January 20th, so you would know if you'd gotten it. Probably the folks that renewed, we anticipate that if they've renewed prior to the new administration, that in all likelihood the Trump administration would not revoke the renewed DACAs. But a new application, we're not sure what would happen with that, because if during the first 100 days of the presidency he decides he's going to immediately get rid of the DACA, then those individuals are left with applications that are going to be denied. And one of the risks with DACA for the individuals who applied was, well, what happens if they don't renew it? Will then immigration authorities have my information? You could only apply for DACA if you were out of status. So, for example, if you had entered unlawfully with your parents or something, or you had been in lawful status, like came on a tourist visa but had overstayed, you were out of status, you could apply for DACA. And so DACA was only for folks who didn't have other options. And so immigration is now aware that if they take away DACA, these folks are not eligible for immigration relief, and they're not here lawfully. Some DACA recipients may have other avenues, and anyone who has DACA really needs to consult with an immigration attorney. So what the word is amongst the immigration bar is that our phones are all ringing off the hook, that people are reaching out, they're doing consultations because they want to consider their options. And sometimes, you might have an option through a family member or through an employer, through other types of non-immigrant visas or asylum or something else that an individual should reach out and do a consultation and take a look at their options if they have DACA. So as a member of the American Immigration Lawyers Association, I'm on their webpage every day getting their news updates to see what the word is in Washington, what the changes are, and all of us on a daily basis are receiving calls. So it's a very crucial and interesting time in the practice area because people want to know what to expect and they're concerned. So to be eligible for DACA, immigrants had to have entered into the United States before their 16th birthday, before June of 2007. They have to be currently in high school or a high school graduate or honorably discharged from the military. They have to be under 31 as of June 15th, 2015, and have not been convicted of a felony or a significant misdemeanor or otherwise pose a threat to national security. So not everybody is eligible for DACA. There certainly is a screening process. But what will happen to individuals who have applied for DACA, already have DACA, or are considering applying now, come January 20th, remains to be seen. We do anticipate that folks who've already renewed, that it would be unlikely that the new administration would revoke it until the end of the renewal period. So the policy was created, as I said, because these are low-priority individuals who are generally good citizens. We've invested in them. If they attended U.S. high schools and colleges and universities, these are folks who've contributed, and our country has invested in them, and we're going to see a return. Approximately 65,000 undocumented students graduate from U.S. high schools on a yearly basis. So it's a great growth area. So when they were researching for DACA, it was estimated that 1.7 million people could possibly be eligible. In June of 2016, USCIS had received approximately 844,000 initial applications for DACA, and many of those were approved, over 88%, and some were denied. And it was clearly, a lot of these cases came out of California, Texas, and also here in Florida. President Barack Obama announced some changes in 2014 to DACA and to expand it to include undocumented immigrants who entered before 2010, and to eliminate the requirement that applicants be younger than 31 years old and lengthen the renewable deferral period. And none of this has gone forward because this has been stuck in litigation. It's been before the Supreme Court, and it was a 4-4 split. And the Pew Research Center estimated that had this gone forward, would have increased the number of DACA-eligible folks by 330,000. So the Supreme Court has issued a temporary injunction and doesn't affect existing DACA, but the new changes to DACA were not implemented. And they effectively blocked it. And so it has not gone forward. And that also includes DAPA. And DAPA was deferred action for parents. And those parents would also have been eligible to get some status if they had a U.S. citizen or lawful permanent resident son. And many of us, immediately when the DAPA passed and the DAPA executive action was issued through a memorandum November 14th, 2014, we immediately went into action in the nonprofit and clinical world, setting up information sessions for individuals who might have been eligible for the DAPA, and in the end, that didn't go forward. So during his campaign, President-elect Trump said that he intends to end the DACA program. But since the election, he's not yet said exactly if, when, or how he might do this. And so we will not know until after January 20th, when the new Trump administration takes power, what his administration officials might do. And he has not yet named, as of this morning, I'm checking every day, he has not yet named a Secretary of the Department of Homeland Security. There are names that have been floated, but he's got a pretty conservative on the immigration front Attorney General with Sessions, so it'll be interesting to see who he selects and what their position is. I believe he's looking at a Texas, let's see, I think it's, I looked at this morning, McCall. So Texas Representative Michael McCall is at the at the current moment, somebody that's getting a little bit of buzz as a possible Trump pick. However, a lot of the sort of conservative think tank folks on immigration, and if you're interested in looking at some websites on immigration and, different perspectives, the sort of most extreme conservative groups are the Federation for American Immigration Reform, FAIR, and they're not in favor of Michael McCall, and also the Center for Immigration Studies. Those are more conservative think tanks on restrictionist immigration. The Migration Policy Institute is a bipartisan think tank on immigration, excellent resources, and I can provide these links. I don't think I put them in the PowerPoint, but I'll pass those on to Dean Ioannidis so that we can get those out to you. And I also recommend looking at the AILA resources and the some of the AILA resources on immigration. Now, AILA, of course, is not neutral because AILA is the American Immigration Lawyers Association, which is the private bar for immigration attorneys. So everybody has their own perspective, and AILA is very much pro-comprehensive immigration reform. So we'll see what happens. These are very interesting times. So the current policy of prosecutorial discretion that shelters some unlawful immigrants by focusing on violent criminal deportations as a priority could be canceled by Trump. And he has promised and campaigned on deporting the 11 million undocumented immigrants in the United States. Talked about different, sort of deporting them with giving them the right to return lawfully. There's a lot of immigration leaders who are afraid of raids, possible abuse of discretion, and some of that has to really be balanced with, the processes. So you can't just round people up and deport them. Individuals who are apprehended by Immigration Customs Enforcement within the United States who have been here for a certain period of time have the right, typically, if they have not been ordered removed before, to go before an immigration judge and possibly may be eligible for immigration relief. There are significant, profound backlogs in our immigration court system right now. I can tell you does anyone else know what they're going to be doing March 13th, 2019? I do, because I have a court hearing. That's how backed up cases are in different immigration courts around the country. I think there are some cases I heard up in Chicago in 2020. So our immigration court system, which is an administrative court system, is severely backlogged. So if you round up 11 million people, many of them are going to be placed in removal proceedings and then are going to be eligible for immigration relief of some sort. It's an estimated 5 to 6 million people are in mixed status families. They may have a relative who could petition for them. And so, if they haven't been able to reduce the backlogs in this administration, I think that would require significant fiscal resources to the immigration court because the system is significantly backlogged. Immigration judges themselves are, identifying compassion fatigue and exhaustion with the number of cases that they have to hear. So we do have due process in immigration, somewhat limited, not the same, at the same level, but you have to hire more judges and prosecutors if you're going to round up 11 million undocumented immigrants because they do have the right to defend their case. Now, we'll see. We'll see what happens there. Refugees. So one of the campaign promises was that Trump would want to stem the tide of Syrian refugees coming to the United States. And he in particular spoke about blocking Muslim immigration from areas of the world where there's a proven history of terrorism. And that's something that clearly his supporters were huge fans of that campaign promises, and those of us who represent immigrants and are committed to the rule of law were concerned about those statements. So what have we done in the past? We actually had a system after September 11th of registration, and I'm going to talk a little bit about that in this next segment on enforcement, the NSEERS program and the registry, the special registry. And I happened to be a law student at that time and had fellow law students that were in the United States on student visas that were called in, and it proved to be a fairly ineffective national security and intelligence tool. So we'll take a look at that. So Trump announced a plan for reforming immigration, and in his plan, one of the main sort of pillars of the plan was this building of a wall that the Mexican government was going to pay for. And how they were going to pay for it, how this was presented throughout the election was through remittances. So, many millions of dollars, billions of dollars come into Mexico through individuals with family in Mexico. They may be undocumented immigrants working in the United States. They may also be lawful permanent residents and U.S. citizens sending money to family in Mexico. The Mexican president was clear that this is not something that is likely to happen, and how Trump was sort of presenting it would be a negotiation tool, that they would get the Mexican government to pay for a wall. So I think that's pretty unlikely. And there also is legislation. The Fence Act was passed under the George W. Bush's administration, and they've covered nearly 500 to 600 miles with fencing and border barriers, and then pushed sort of the migration to the most dangerous parts, and thereby reducing it significantly. And the Obama administration, frankly, has deported more immigrants and blocked more immigrants from coming in than any other presidency. So that is interesting. So it's highly unlikely that a wall will be able to be sort of instantly built. That's something that Congress would have to pass legislation. They would have to amend the Fence Act. There would have to be funding for it. In all likelihood, it may not be the best strategy, both economically and physically, geographically. It's certainly been analyzed that certain portions is just not a good idea, not feasible, and not the best use of resources in terms of border security. And there have also been critiques of the wall as really the way to catch drug dealers and some of the scarier individuals that they're concerned about, that really, a lot of times those folks are coming in through lawful mechanisms or utilizing the ports of entry and sneaking drugs and other items in through trucks and other things, and they're not actually the ones crossing through the desert. So that'll be interesting to see how that plays out, but I think it's unlikely that the campaign promise will be exactly followed through on, because it's just something that the executive doesn't have the lone authority. He would have to work with Congress. So a Muslim registry, NSEERS. So the NSEERS program came into effect after 9/11, and the transition team, immigration expert for Donald Trump, Chris Kobach, has said that the Trump administration is considering reinstating this database of immigrants from Muslim-majority countries, something that the federal government did from 2002 to 2011. The Kobach proposal isn't the same thing as the database of Muslim U.S. citizens that Trump briefly floated and then sort of has walked back upon. Under NSEERS, certain foreign nationals and citizens in the U.S. had to come into immigration offices for fingerprinting and photos and interviews, and then had to check in at designated intervals. And this was males, not females, and it was Muslim men and certain non-immigrant visa statuses between, I believe it was the age of 18 and 30, but I might be wrong on the upper end of that age. But I can tell you At the time, I was a law student, and I had friends that were called in and, of course, released. And then individuals were placed in removal proceedings for such minor violations as not changing their address or briefly falling out of status. And this special registration system was selective. It only applied to folks on non-immigrant visas and only applied to men over the age of 16. So the NSEERS program was no longer utilized by the Obama administration. It was deemed to be largely ineffective as a national security strategy tool, and most of the people that were placed in removal proceedings were ordered removed based on civil immigration minor violations, and they did not get much intelligence out of that system. There were 25 countries on the special registration list, and 24 of those were majority Muslim countries, and the 25th was North Korea. So more than 80,000 men were put into NSEER's special registration database, and Muslims and non-Muslims from suspected countries alike. But to Muslim American and civil rights groups, the fact that the Bush administration was responding to 9/11 by ordering thousands of Muslim men to show up to register was discriminatory and very harmful to many communities. And again, not particularly effective. Unfortunately, it would not be difficult. I'm sorry, I'm not being neutral on this. It would not be difficult to reinstate this. Now, I think a registry or of just Muslims, in itself, I think you have major constitutional issues there, and I don't think that would pass constitutional muster. But individuals on non-immigrant visa, that was, although NSEERS was challenged to some extent, I think this would, if they reinstated, I think that would not likely fail. So there is a lot of authority that the executive branch has over immigration policy, and when the federal government enacts an immigration policy that has foreign policy consequences, the courts are unlikely to intervene. So the NSEERS program is likely a possible reinstatement of that. So in the first 2 months of the NSEERS, 1,000 registrants were detained, and all but 15 of them were detained for civil violations. Something as simple as failing to update your address. There's a rule in immigration that you have to keep your address current with the Department of Homeland Security within 10 days, and that was something that immigration attorneys alike, as well as immigrants, largely didn't pay much attention to. So I can tell you everybody that I knew started filing address change forms, such to the extent the government had an overwhelming number of address change forms. So most of the violations on NSEER were brief overstays. Some of them had applied for green cards, just hadn't had their applications. And visa overstays were the biggest problem. So back to the wall. It was a campaign promise. I think it's highly unlikely to absolutely impossible, I guess I'm going to say, that Mexico would ever pay any portion of a wall built between the United States and Mexico. The Mexican government has indicated such, and it's not really clear that it would have been an influence to change the remittances policies, because that is a mixture of lawful permanent residents, U.S. citizens, as well as undocumented immigrants sending money back to Mexico. Congress would have to pass a bill. It's not clear that there's the support for that, even within the Republican Party. And the Secure Fence Act of 2006 was already passed, and there wasn't enough funding to complete that, but they did complete nearly 600 miles of secure fencing. Financial feasibility of deporting 11 million undocumented immigrants. Since coming to office in 2009, Obama, who some immigration attorneys have referred to as the deporter-in-chief, Obama's government has deported more than 2.5 million people, up 23% from George W. Bush. And Obama has deported more people than the sum of all 19 presidents who governed the United States from 1892 to 2000, according to government databases. So I think that it's very expensive and ineffective to round up 11 million undocumented people. I don't think we have the resources, both financially and judicially, to do that. What changes can you anticipate with business immigration? So President-elect Trump has made pretty inconsistent statements on business immigration. As a businessman, you have heard, and we've all heard in the media, that he certainly used temporary workers, especially the H-2B visas and the H-2As, possibly in some of his business endeavors. So he's made inconsistent statements on the highly skilled workers, the H-1B, and this visa class requires candidates to be employed in a specialized industry, which typically means the science, tech, engineering, and medical fields. And President-elect Trump has said during debates that he would, possibly soften his position on this and recognize the importance of keeping talent in the U.S., but then changed his stance again, releasing a statement on his campaign website that indicated he intended to end forever the use of H-1B for cheaper labor. So we know that the restrictionist conservative immigration think tank, CIS, and Federation for American Immigration Reform are in favor of reform to the H-1B system, and then there's concern that this displaces American workers. And then you have companies like Microsoft and other big tech industry companies that are advocating for increased numbers for the H-1B. If you worked in immigration and business immigration, you know that the cap for H-1B, the number of H-1B visas available, is never enough, and the cap is usually met within a matter of a few days of the period that it's open for applications. And companies, and Bill Gates has been very outspoken about the possibility that U.S. companies might take their work overseas because they can't get enough qualified workers because there aren't enough Americans with the high skills needed to run their businesses effectively in the United States. So it'll be interesting to see there. So annually there's about 65,000 foreign professionals that work and 20,000 graduate students from universities that are admitted into the country under the H-1B. And President-elect Trump sent these mixed messages on the campaign trail, sometimes criticizing the visas, other times calling them an important way to retain foreign talent. The Migration Policy Institute in AILA has a lot of information on the need for expanded H-1B programming. The H-1B program has been oversubscribed for years, and again, as I said, typically there's much greater demand than the quota provides, and less than 30% of timely filed applicants were able to get the visa in 2017. They ran out of visas within I think 4 or 5 days last year. So the President-elect also recently released his 100-day plan that says he will call upon the Department of Labor to investigate visa programs, but hasn't said much more than that. So Senator Sessions is well known for being a hardliner on immigration. Last year he released a memo entitled The Immigration Handbook for the New Republican Majority, which lays out his views on why immigration reform has worked against American citizens and states. So if you want to know, sort of his posturing, take a look at that. And the memo describes skilled immigrant workers in Silicon Valley as a hoax, and he speaks very critically of the H-1B and L-1 intercompany transferee visa programs. So it'll be interesting to see, what the interplay is between the Secretary of the Department of Homeland Security and the Attorney General. But again, to change the H-1B program, that's statutory. That has to go through Congress. So, you're not looking at something immediate within that. So I know I'm getting close to the end of my time. I'll breeze through these last slides here. Obviously, President-elect Trump's campaign on renegotiating NAFTA, which contains certain visas as well, the TN visa, which is a work visa for Canadian and Mexican workers, and we don't know what will happen to this visa at this time. But again, that would have to go through Congress. That's not something that the President-elect can remove without Congress changing the law. So anything that is solid in our Immigration and Nationality Act it would have to be amended by Congress. So it could not come through an executive action. And that's, I think, what's really important for people to remember is that legislation has to be constitutional, and if it's a legislative change, it has to go through Congress. It's not something the executive can just do. But programs like NSEERS and the DACA, those are things that the executive, they aren't law. They are in the same sense as something that's passed through Congress, and so you have greater executive authority. And the decision on who to deport, because we know we have 11 million plus individuals who are out of status in some form. So I think that the E-Verify program is also the electronic verification program. Trump has also contemplated requiring all businesses to use that. Many businesses are currently using that, and that allows employers to verify employment authorization before a worker's employed. Not the most controversial element of changes. So again, changes to the INA, Congress. Changes to visa availability, Congress. Changes to the type of visas, Congress. Grounds of deportability and admissibility, Congress. Ending birthright citizenship, also campaigned upon, Congress. Those are all things that have to be handled by Congress. Whether or not to deport somebody that you've apprehended or encountered, that's within the prosecutorial discretion. So that's where you have a lot of the fear. So turn it back over to you, Dean. Thank you so much.
Thank you, Professor Cran. That was absolutely fantastic. And actually, we have had 30 people participating live from around the world. And we just thank everyone for joining us. This is the time, if any of you have questions, you may use the chat feature to send those questions. We actually already have one that came in, Professor Cran. Have you heard about any changes to the EB-5 Immigrant Investor Program?
Yeah, so any changes to the EB-5 investor program would have to be congressional fixes. I have not heard of any immediate changes or campaign promises on that. There has been some talk about security screening, but that is something I'll certainly be looking out for as well.
Thank you. Another question that we frequently get from students in the program and students considering the program is their ability to practice in the field of immigration law if they are licensed in a state but practicing in a different state. Do you have any guidance for these students?
Yeah, so immigration law is federal administrative law, so it is possible to practice immigration law with a bar license from any state, in any state. So, for example, I have many friends that practice immigration here in Florida who are licensed in Washington State or licensed in California or licensed in New York, and you can practice immigration law. Now, you can't dip into criminal or family in Florida if you're licensed in Washington, but you can practice immigration law. And a lot of immigration law lawyers represent individuals right now. I just got a call this morning about somebody who wants us to take a case for a guy who's got an appeal in Texas. So I could take that case, even though it's in Texas. It's an appellate case. If I wanted to take that case, I wouldn't be practicing Texan law. I'd be practicing federal immigration law. So that's exciting about the practice area. That's one of the reasons I chose it, was that versatility. I don't want to take too many bar exams.
That's right. Thank you, Professor Cran. And another question has come in privately. Can the president modify the rules to deport legal permanent residents?
So no, the rules to deport lawful permanent residents are found in the grounds of inadmissibility and deportability, INA Section 212A and INA Section 237A, and that's in the statute, and those rules would have to be changed by Congress. So what the president can do is propose, obviously, new legislation and work with Congress. And so that is possible, but that's not going to happen likely within the first 100 days.
Wonderful. Thank you.
And quite sweeping.
And for those of you who are not as well versed in immigration law, INA, Immigration and Nationality Act, and the specific sections were 212A and 237A of the Immigration and Nationality Act. So you should be able to pull those up as well through Lexis, Westlaw, Bloomberg Law, or independently. You can find them on the internet. Another question has come in. Professor Cran, are you able to see this one in the chat area?
Yeah, but I don't anticipate that there'll be any change to the H-1B visa system that quickly. Again, that's statutorily based at this time, so I don't anticipate that would change this year.
Wonderful, thank you. And while we're waiting for any additional questions to come in, oh, here we go. Here's another one. Professor Cran, what sanctuary policies are under threat of executive action and federal funding?
Yeah, so President-elect Trump and his administration, or his developing administration, has spoken out very much against sanctuary cities, and I think it's going to be very challenging. I believe that this is going to, be the kind of thing that would be a fight, because immigration law is very clearly in the authority of the executive and Congress has broad discretion. It's federal, so states typically don't, and local municipalities have the same authority. However, there are certain deals that were put into place, INA 237G or 287G, which we have an agreement here in Jacksonville. Local law enforcement here in Jacksonville were deputized to be working with ICE, and individual municipalities were able to elect to sign up for that, and that's one way to respond in areas where you have those agreements coming into play, and you have a definite movement around the country fighting with those sanctuary policies.
Thank you. And another question has come in. This one is related to what might happen if President-elect Trump cancels DACA.
So I'll just give my personal feeling. I think it would be an extraordinarily unwise thing to cancel DACA. So, there's definitely a split among attorneys. People were talking about whether or not they were going to encourage people to still even file who didn't have it yet. And we actually just filed a DACA application the other day for an individual who's very aware of the risks, but he had a very clean application, been here since early childhood, and had a high school diploma and was in college. I think these are not the folks that the majority of Americans want to see removed from the United States. However, he has the authority to get it. Now, I think folks who've renewed, I don't think that they will be able to easily undo the previously renewed applications. But I know that DACA recipients are scared, and I highly recommend everybody consult with an immigration attorney, anyone who has DACA, because there might be other options. You want to take a look at all of your options. Maybe you have a family member. Maybe there's some way an employer could sponsor you, and anyone with DACA should definitely reach out and consult. We are doing an event on January 19th. If anybody is in the area and wants to come and join us, we'd welcome your participation. Obviously, we'll be helping individuals who have questions about DACA here at the school. And you can email me here at the law school, and my contact information is there. So please reach out directly if you have further questions.
Thank you, Professor Cran. And actually, when we send out the link to today's recording and the PowerPoints, we'll also include Professor Cran's email address. So if any of you have additional questions, you may also reach out directly to Professor Cran. We'll also include the websites for the organizations that Professor Cran referenced earlier today. We have another question that came in. This is a question from someone who's an international lawyer. Can you practice immigration law without a bar license? I know you referenced if you have a license in one state, if you can practice in another. What would be the policy for somebody who is in the U.S., is a foreign educated attorney, but wants to practice immigration law?
So really, there's a very limited regulation in our immigration regulations that allow individuals who work at certain board-certified nonprofits to become Board of Immigration Appeals accredited representatives. And so somebody without a law license could go work at a nonprofit that was an accredited organization and practice immigration law through that system, but it could only be in the nonprofit sector. You cannot practice immigration law without a license in the private sector. So there are certain churches, Catholic charities, Jewish immigration services, World Relief, many nonprofit organizations have accredited representatives. I know here in Jacksonville, our own legal aid office has two accredited representatives and 2 attorneys. So, so you do see that, but you can't run your own private firm.
Okay, thank you. And while we're waiting, we just have maybe a few more minutes because we started a tiny bit late. If anybody has any final questions, and while you're thinking of those, we just wanted to walk through. We're putting together the speaker series events, and for those of you who are students, the faculty student hangouts for the spring semester. So stay tuned. Once those are scheduled, we'll have more information on our website, and for students, we'll have more information in your D2L class sites. We've included our website links here. Our contact information was on the previous slide. It looks like there are not any more questions that are coming in. So with that, my final thought is thank you to everyone for participating today. And Professor Coran, thank you for a wonderful presentation. And I will let you have the final say.
Great, thank you everyone. And again, if you have any questions, I'm always open to taking emails. So please feel free to reach out, and good luck to you.
Thank you. Bye-bye, everyone.